Everyone, today I will be talking about employment contracts for physicians and advanced practice providers. There are several elements within the employment contract. To start with is a term of contract. Contracts usually have a set duration of time. Commonly it is 1 to 2 years with a defined end date. On the other hand is the evergreen contracts, which are designed to renew automatically on an annual basis following the initial term. Termination of contract. Termination can occur without cause where either party, whether it's an employer or employee, may end the contract by providing a written notice within a specified number of days. Usually it is 30 to 90 days. Nowadays we have seen it go up to 120 days. A contract can also be terminated with cause, which requires the employer to specify the reason for termination, such as a breach of contract. One example is failure of the provider to complete medical records in accordance with the hospital policy. Other reasons to terminate a contract are substance abuse issues or serious patient safety concerns. Contracts may automatically terminate upon the death or disability of the provider or loss of the medical license of a provider. Additionally, contracts can come with a notice of non-renewal. Physicians and advanced practice providers must carefully review the termination clauses in their contracts. Additionally, physicians or APPs possess the right to terminate the employment with cause if the employer breaches the contract. Next one is contract provisions. There's several of them that one has to carefully look into. One is the location. The designated work location for the physician or APP is a crucial provision, whether it's an office setting, hospital, or a nursing home. It should be clearly stated in the contract. Next is the duties. The contract should clearly define the job responsibilities of the provider, distinguishing between a clinical versus a non-clinical role, inpatient versus outpatient job, and any specific procedures required, if there's any supervisory responsibilities of the physician or APPs, and if there's any teaching commitments of the physician towards residents and medical students. Next is the schedule. The provider's work schedule must be precisely outlined, including the number of hours per day, number of days in a week, and number of shifts per month, and clear differentiation between night and day shifts. On-call requirements should be clearly stated, including the frequency of on-call during nights and weekends, along with details on compensation and the extent of coverage. Professional liability insurance. Physicians and APPs must fully comprehend the type of malpractice insurance they are covered with. There are two types of malpractice policies that are available. One is the occurrence-based and two is the claims-based. In an occurrence-based policy, one is covered with all occurrences that happen during their employment. With a claims-based policy, one has to obtain a tail coverage if a claim has occurred after the end of the employment. Next is the compensation. The contract will clearly specify the base salary. If there's any bonus structures like production, which is usually in the form of RVUs, any quality incentive bonus at the end of the year. Other bonuses could be sign-on bonus and relocation allowances. Additional benefits will include paid time off, which include vacation time, sick leave, and CME time. Other benefits that one has to look for is the retirement benefits such as the 401k plan or 403b plan, health insurance benefits, and disability insurance policy. Next is the non-compete clause or the restrictive covenant. The specifics of this clause may vary based on the state where the physician practices. Typically, the restrictive covenant has got two components. One is the time duration, which is normally 1 to 2 years post-employment, and other one is the geographic radius. Next provision is non-solicitation. Typically prohibits employees from soliciting former partners and colleagues. Outside work. Most contracts nowadays include restrictions on a provider's ability to undertake duties beyond their contracted work, clinical work such as moonlighting, non-clinical work such as speaking or writing engagements. Employees are required to inform their employer if they participate in any such activities. Next is arbitration provision. It's a clause that permits disputes between two parties to be resolved by arbitrators. The provision is commonly included in contracts as a means to settle non-clinical issues outside of the court. Clinical issues are most likely to be going through the peer review committee. Key elements of this provision typically specify the location of the arbitration, kinds of claims it covers, and the allocation of legal cost. Thank you.